most importantly, Mr. Zaffar Shah, who is a senior advocate at the High Court of Jammu and Kashmir and Ladakh. A very warm welcome to one and all. Now, a very famous quote of Isaac Newton, which is often quoted in scholarly papers, is that if I see any further, it is because I stand on the shoulders of giants. And it is our good fortune today that we have with us one such giant who would, without a doubt, whose experience, whose knowledge, and whose credibility in the field would definitely help us in seeing beyond, help us doors in seeing beyond and seeing farther by stepping on his metaphorical shoulders. So it is an arduous task to welcome someone whose name is ubiquitous with legal practice in the region. One of the most famous and iconic figures in legal practice in the region. Not only that, but I would say that Mr. Zaffar Shah's name is part of our legal folklore. And very few lawyers achieve what he has achieved. Very few lawyers have the reputation that he has attained. And it is with sheer dedication, his courage, and a sense of upholding what is right, what is just, that Mr. Shah has achieved what everyone aspires to achieve amongst us. In fact, I remember the first time I met Mr. Shah, I told him that regardless of what one wants to be, but when a Kashmiri joins a law school, the first thing he wants to be is he wants to be Zaffar Shah. And with this, I welcome you, sir, to today's lecture, which is an all important lecture and something which I know personally that you are interested in, which is the difference between academics and practice. More importantly, it is not the academics of a professional academician, but the academics of a law student in a law school. In fact, Mr. Shah would most probably talk more about the transition that happens once a law student becomes an advocate and leaves college, and what he reads in his books, what he reads in his statutes, if he reads any, in the law school, and how he has to apply the same in the practical field before the courts, before arguing before the honorable benches and before courts, before different courts. So, without further ado, I would invite Mr. Zaffar Shah to kindly start today's lecture. So, the mic is yours, sir.
Thank you. Thank you. Thanks for the kind words you have said about me. And I always believed in few things in my life, and I continue to believe in them. That is learning. And the learning has to take place in your mind. You might get information from outside your mind, but the learning has to take place in your mind. When I am saying learning has to take place in your mind, it essentially means this, that you have to be a thinking person. You have to think. Thinking has its own structure, thinking has its own meaning. Books have been written where interestingly they say, thinking about thinking. What is it that we think? What is the source of our ideas? What is the source of our thoughts? And not only that, another important element of this thinking is our perceptions. Remember, we all have perceptions, but we choose our own perceptions. We have options in perceptions. So therefore, when I say thinking, it will also mean the perception which you have, which you hold, and that perception must be based, it must be rooted in realism. Yes, your thinking can be abstract, then there are levels of abstraction. In depth, people have a different understanding of issues involved. Superficial understanding has a different view of the issues. Now, having said these few things which are more psychological and more important as you will grow in age and have your experiences, I I have a lot of things to share, a lot of things to say. And since I'm not treating this program to be like a classroom where I have to deliver a lecture, I don't have to explain you the law, the provision, the article, the section, or any judgment of the court, Supreme Court, or the High Court. But since I'm talking to the youth, I'm talking to the young lawyers who have just obtained their law degrees, come out of the law schools, their schooling, their college days, their university days have trained their mind in a different manner. And when they join the profession, they don't find it in the same discipline as possibly they might have been in the school or in the college. The whole world is open to them. The world that is good, the world that is not so good, the people who interact with them are good people or may not be so good people, and the kind of cases which they get, they are not straightforward and simple cases, meaning thereby that if you get a brief, you just can't think simply that it falls in this section, so therefore the answer lies in that section. It doesn't work that way. The case which you might get, the brief which you might get, will attract too many laws. When I say it attracts too many laws, I assume that as a young lawyer you may not be aware of all the laws. That's where the hard work comes in. The most important thing for a lawyer is the level of awareness of the legal world, the laws made by the legislature, the rules made by the competent authorities, the notifications, the circulars. He has to be aware of them. So when he gets the brief, he will find that instead of one law, there are other laws also which are applicable. It often so happens that you might find one law contradicting the other one. You may not be able to harmonize these laws, but nevertheless, since you have a court appearance and it is a job to put up your best advocacy before the court, you have to, before you enter the court premises, when you are still at home and thinking about the case, you have to have a clear sort of roadmap. You have to have a clear mind as to what is it that you want. What is it that you want the court to do? And if you want something the court to do, you also have to be aware of the impediments in achieving what you want to achieve. And then how do you circumvent, find solutions to those impediments? There could be legal impediments, there could be logical impediments, there could be impediments of fairness, there could be even impediments of morality. These are various kinds of impediments which arise in the mind when you sit on your table to think about the brief. But this, what I am telling you, is a different level, which you will, as I said earlier, you will gain it with maybe next 5 or 10 years of your practice. You'll appreciate it better and you'll understand it better. That when we apply the law, when you get the brief, how this law is applied and how you make a non-contradictory integrated view before a court. That should be your object, that should be your goal. Non-contradictory integrated view, so that the judge feels confident in deciding the case. The judge feels confident that the premises on which the judgment is founded, those premises are not questionable. The judge feels confident that the laws which you cite are the right laws which are applicable. They are the appropriate laws which are applicable in decision-making process. These are very important things, and it also involves your own credibility, whether you are misleading the court or whether you are genuinely making a statement or a submission before the court, whether it is a submission on facts or whether it is a submission on law. That involves your personal honesty, personal sincerity, personal integrity. That's equally important to a judge. You have to have that credibility in the court of law. So therefore, when you go to the court or when you come out of the law school, coming back to the original premises, when you come from the law school, you have to be aware of, first of almost have rudimentary knowledge, means some basic knowledge of the total number of laws which are available. I always cite an example to the people, say, which always has explains what I am saying, that somebody's horse was detained by a police officer. He rushed to the court and told the lawyer that please get my horse released from the judge. Now here is a brief for you. How do you do that? If you are not aware of, you are dealing with a horse, an animal. It's not a human being. Will you apply for a bail for a horse? Then you want to be clear in your mind for whom the bail law is applicable. Is it applicable to the animals also, or it is applicable only to the humans? Yet you want the release of a horse. Under which provision of Code of Criminal Procedure you will approach the court? And how do you choose the court? There are several courts. We talk of city of Srinagar or even in the rural areas. There are several courts. Will you go to the High Court? Will you go to the Supreme Court? Will you go to the District Judge Sessions Court? Will you go to Chief Judicial Magistrates Court? Will you go to Magistrates Court? Or even will you go to Tahsildar's Court, which is also the Court of Executive Magistrate? Where will you go? These questions must come to your mind so that you follow a proper forum. Now, when you get such kind of a case, another important thing for you is you can't tell the client, you wait, I will come tomorrow because I will go to home, I will read it and then do your case tomorrow. You will lose the brief. He's not interested in that. He wants quick relief. So you have to be aware of the laws which are applicable. And also in Jammu and Kashmir, when you find the kind of cases, the nature of cases which usually come to the courts, that should help you in knowing the laws. In civil law, for example, everybody applies for a stay order. So you have to understand what Order 39 is, why is it written, what are its requirements, how far Specific Relief Act is connected to Order 39 of CPC. All these things are required to be known to a lawyer who goes in for actual legal practice in a court. You will learn it also by experience, but at the same time, you have to also theoretically know this. It is a later question that how you apply that law and how do you state what we call as material facts on which those laws are applicable. So before I go on telling you all this, I would prefer, and I told your organizers earlier also, let us make it an interactive session. Let me see what is it that you want to know from me. Can any person ask a question? What is it that he wants to know from me? I'm not interested in lectures much, but I would like to know what you are thinking. Where do you find gaps in your thinking? What is it that you want to know so that I can share my experience with you? Ask any question, any of the participants.
Okay, so
Assalamualaikum to all the members.
Just one person at a time and let him identify himself, no?
Assalamualaikum, sir.
Walaikum assalam.
Whosoever has a question may raise his hand and unmute his mic and ask a question one by one.
yes, please.
That's right.
Mr. Abid Zahoor has raised his hand. Abid sir, please turn on your mic and ask the question.
Abid sir, kindly unmute your mic.
Hello. Hello.
Yes, Abid sir, you're audible. Please.
Hello. Sounding sir. Sounding sir.
Walaikum assalam. बोलिए.
Sir, I have a question. It is just related to a case pending before the trial court.
It is a case. Sorry.
Related to case 12.
Let me understand. There is a case. No, there is a case pending before the court.
Yes, sir.
You want a legal opinion or what? You are finding a shortcut to your own work. Maybe I will oppose you. It's not appropriate for me to speak on a pending matter. No, come on, ask. Come on, ask. Okay, please ask.
Yeah, it's a civil suit regarding the dispute of a property in between two parties.
Okay.
What happened in ex parte order was issued against me.
ex parte order, not an ex parte decree. Okay.
Yes, sir. Yes, sir. Yes, sir.
What?
No, it's basically it's a decree. It's a
So
decree.
try to use
Expiry decree
appropriate.
has been passed against
Wait,
me.
wait, wait, wait,
Afterwards,
wait,
I
wait,
filed
wait,
an application for setting aside that expiry.
wait, wait, wait,
Sure,
wait.
sir.
Use when you are in a court of law. No, you're not before a court before me. But also, I'm trying to tell you this. Try to use more appropriate language. That's what I'm saying. So you have a case where somebody has got an ex parte decree. That's what you are saying. Am I right? Hello?
Sure, sure, sir. My apologies.
No, no, it's all right. You got an ex parte decree. Then what next?
Against me, then I filed an application for setting aside that decree.
Okay.
And that was posted for arguments of say we can say in October.
Yes.
And another application for thrashing the voluntary that is lying in that disputed property.
Just one another application you filed in addition to
A
the app.
walnut, exactly, sir. In addition to that application, I filed another application to allow me to thrash the to harvest the walnut tree that is lying in that property.
Okay, it is a land where some crops had grown.
Exactly, sir. The crops are perishable, so I don't want that
Okay,
to be
you filed an
get wasted.
application ke allow
So
me
I
to reap the
filed an
crops.
application.
Okay, okay, okay. Then what happened?
Yes, sir. Exactly, sir. So, later what happened that they just kept that application pending for 28 days.
20 days. Okay.
28 days, they just kept that application pending.
Okay.
On the date on which the judge was about to pass the order, in the morning to the walnut.
पूछिए ना. Continue asking question. I'm still not getting the question. On the date in the morning the judge was about to pass order. Then what happened?
In the meantime, the opposite party harvested that walnut.
Yes, I understand that now.
So as per the civil suit, that walnut tree belongs to me, and there were three other walnut trees that belong to the opposite party.
One walnut tree belonged to you and the three belonged to the opposite party. Is that correct?
Yes, sir. Exactly, sir. There were four walnut trees in that property.
Okay.
Now, my issue is that number one, shall I file an appeal against that order,
Which order?
or shall I file a contempt petition that was passed? The order was passed that was not in my favor. Basically, the magistrate passed a direction to the Tehsildar to get that trade thrashed, that trade harvested, and deposit the proceeds of that harvesting before the court.
Of all the four trees or only one tree?
On a single tree that actually belonged to me, not to the opposite party. But the opposite party, just in the garb of that ex parte order, ex parte decree is in against me. They took the advantage of that decree and thrashed the
Yes.
walnut tree.
Yes.
I have two questions: whether I shall go for the appeal against that order because that has been passed against me, or shall I file a contempt petition before the same court which passed the order, which has not been complied with by the opposite party?
No, your thoughts are not right. Point number one, you are saying I will file a contempt. Which order is violated? Which order is violated?
That order in which the direction was to the Tehsildar, not to the parties.
So, but according to you, he has thrashed that tree, that walnut tree, before the order was conveyed.
Like the order was passed at around 10:30 a.m. and around 12:30, 12 noon they harvested. Because what actually the actual practical situation is that some order is working in that court is related to the opposite party. He has communicated the order that आप जाओ जल्दी से जाओ इस जो अखरोट का पेड़ है उसको जो भी करना है कर लो जल्दी से ऑर्डर हो गया अगले दिन।
नहीं, आप जो बता रहे हैं ये मैं समझ रहा हूँ, अब हमको लीगल एंगल से देखना है ना। लीगल एंगल में तो ये
Sure,
नहीं
sir.
चलता ना, उसने बोला इसने बोला, बात छोट सिंपल है। जब भी जज साहब ने ऑर्डर दिया, इफ़ यू अंडरस्टैंड मी
Yes, sir.
करेक्टली, जब भी जज साहब ने ऑर्डर दे दिया, चाहे 10:30
Exactly.
बजे दे दिया, चाहे 12:30 बजे दे दिया, लेकिन ये ऑर्डर जो जज ने दे दिया कि इस पेड़ के अखरोट जो हैं वो तहसीलदार साहब उतारेंगे, उसके बाद वो उनको बेचेंगे, उसका जो सेल प्रोसीड होगा वो कोर्ट में डिपॉजिट करेंगे, ठीक है।
Yes, definitely, sir.
हाँ, बस ये आप मुझे साथ साथ बोलिए ना, आई एम अंडरस्टैंडिंग यू करेक्टली। अब आप बता रहे
Yes, yes,
हैं
yes.
कि
I
अब आप बता रहे हैं कि उन्होंने
yes, sir.
कोर्ट ऑर्डर के बावजूद, इंस्पाइट कोर्ट ऑर्डर, उन्होंने वो अखरोट उतारे उस पेड़ से, यही बोल रहे हैं।
Exactly, sir.
लेकिन एक सवाल आपको फिर जवाब देना पड़ेगा, क्या कोर्ट का ये ऑर्डर उस पार्टी को
Sure.
कन्वे हुआ था कि नहीं, बस इतना ही बताइए आप।
At that point of time, practically it is no.
अगर वो
Because the order was passed in the same day.
नहीं,
Before
ठीक
1
है,
or 2 hours.
आई
Practically
अंडरस्टैंड,
no.
आई अंडरस्टैंड। अगर कोर्ट ऑर्डर कन्वे नहीं होता है तो उसका मतलब होता है फिर कंटेम्प्ट
Yes,
नहीं
sir.
बनेगा, सीधी सी बात ही है, नंबर वन। अब दूसरी बात मैं
Right,
आपको,
sir.
अब दूसरी
Right,
बात
sir.
पूछूंगा मैं आपको, जब जज साहब ने सुबह 10:30 बजे ये ऑर्डर दे दिया, क्या दूसरा वकील अपोजिट पार्टी का कोर्ट में प्रेजेंट था, उसकी हाजिरी पड़ी है कि नहीं?
That's to be confirmed.
हाँ, तो फिर कैसे? अब इसका
That is to be
ये
confirmed.
ये होते हैं ना, दीज आर द मटेरियल फैक्ट्स, एज अ लॉयर यू आर सपोज टू नो। अगर दूसरी पार्टी का वकील हाजिर था,
Yes.
देन इट वाज हिज रिस्पॉन्सिबिलिटी टू कन्वे इट टू हिज क्लाइंट कि आप थ्रैश इस पेड़ को मत करो, ठीक है। लेकिन अगर ये नहीं होता है, आप ये साबित
sir.
करने में फेल हो जाते हैं कि उस पार्टी को पता था, फिर मेरी राय में कंटेम्प्ट नहीं है। दे इशू नंबर 1 आपके लिए। इशू नंबर 2,
Yes.
अगर
Yes,
आप
sir.
अगर आप कल को जीत जाते हैं, जीतना ये मतलब होता है अगर आपकी एप्लीकेशन फॉर सेटिंग असाइड द एक्स पार्टी डिक्री अलाउ हो जाती है, ठीक है, तो डिक्री टूट जाती
Right.
है, क्या होगा?
Right.
डिक्री टूट जाती है। जब
Right.
डिक्री टूट जाती है,
Totally.
जब किसी भी पार्टी ने किसी डिक्री के अंडर, किसी डिक्री के तहत कोई फ़ायदा लिया होता है, उस पार्टी ने वो रेस्टिट्यूट, हम उसको बोलते हैं,
Right.
वापस करना होता है। तो वो
Yes, sir.
सेक्शन 144 प्रोवाइड फॉर रेस्टिट्यूशन। आप उस वक्त डिक्री अगर आप
Right.
कामयाब हो जाते हैं तोड़ने में, फिर आपको एप्लीकेशन कोर्ट को देनी है कि साहब इस पेड़ पर से 100 पेटी उतरता है या 200, वट एवर यू से, विच इज़ टू बी प्रूव्ड। और उनकी कीमत उस ज़माने में, आज के ज़माने में 2023 में 10,000 थी या 20,000 थी या 50,000 थी। इसका फ़ायदा इस पार्टी ने ले लिया अंडर द एक्स पार्टी डिक्री, इसलिए इनको हुक्म हो जाए कि वो 50,000, 40,000 जो भी कीमत है वो कोर्ट में डिपॉजिट करें। मगर ये तब मुमकिन है जब आप जीत जाते हैं, ठीक है।
Sure, sir.
Okay, okay.
And yes, sir. There's one important point in that magistrate kept the application pending for 28 days.
नहीं, उसको एक और कानून होता है ना,
On one
उसको
pretext or the another.
ना, ये प्रिटेक्स्ट तक छोड़ दीजिए, इसको एक कानून होता है, द एक्ट ऑफ द कोर्ट शैल प्रेजुडिस नन। वो कानून ये कहता है कि अगर कोर्ट ने कोई एप्लीकेशन पेंडिंग रखी, कोर्ट पे कोई जिम्मेदारी नहीं है कि 5 मिनट में डिसाइड करे, 24 घंटे में केस डिसाइड करे। कोर्ट को अपनी कन्वीनियंस, बाकी केस कोर्ट के सामने होते हैं, लेकिन पेंडेंसी की वजह से अगर कुछ नुकसान किसी को होता है तो वो उस पार्टी को रेस्टिट्यूट करना पड़ता है, नुकसान अगर हो गया। जैसा आप बता रहे हैं, इन माय ओपिनियन, आपको एक तो ये खुद पहले अपने आप को तसल्ली कीजिए कि उनको ऑर्डर कन्वे हुआ नहीं हुआ। अगर हो गया कन्वे, उसके बाद उन्होंने वो उतारा तो तब कंटेम्प्ट बनेगा। अगर आपके पास सबूत नहीं है उनको कन्वे या कुछ हुआ तो फिर कंटेम्प्ट नहीं बनेगा, एक बात। दूसरी बात, अब तो वो पेड़ पर से उतार के ले गए, वो अखरोट भी ले गए, सब कुछ ले गए, बेचे भी, पैसा भी बनाया उन्होंने। आप फिर मेहनत कीजिए, एक्स पार्टी डिग्री को तोड़वा दीजिए, जो ही वो टूटती है उसके बाद ही इमीडिएटली आप सेक्शन 144 में एप्लीकेशन दे दीजिए। ऑल राइट,
Thank you,
Thank you
sir.
so much. Highly obliged.
चल कोई बात नहीं, फीस की बिल मैं बाद में भेजूंगा। चल बोल।
So now you would be responsible for the result of this litigation. So before we take the next question,
Yes.
it's my humble request, kindly keep your questions short, 1 or 2 sentences, and to the topic. The topic is law in practice. The purpose today is to learn from the vast experience that Zaffar Shah has. So please ask questions in relation to how how practice is different from academics, and how a young lawyer or a senior lawyer can flourish and gain from Mr. Shah's experience. So
बोलिए.
please keep the question to 2 or 3 lines. The next would be Abrar Ahmed. Mr. Abrar Ahmed, if you could unmute yourself and ask the question.
Yes, please. Assalamu alaikum.
वालेकुम सलाम. बोलिए.
Sir, my question is brief that can a criminal revision be withdrawn?
Can a criminal
Because I want to
revision?
register. Criminal revision has been filed by the petitioner. At this stage, while arguing the matter, Sessions Court asked him to furnish some documents. Basically, it is a revision filed by department. Now, in order to avoid the filing of those documents, they want to withdraw that revision petition. I want to register that.
No, but revision is against which order? What is the basic case?
Basic cases, an order has been passed by the trial court wherein they have directed the department not to do some act.
Okay.
Now department was aggrieved and they filed a revision petition before the session.
It's a criminal matter.
Yes, sir.
Okay, there was a criminal complaint pending in the trial court.
Yes.
It is not a police challan, it is a criminal complaint.
No, sir. It is a complaint.
Okay. And in that the trial court passed some kind of an order against the department, correct?
Yes.
Against that, what was the nature of that order?
That was it restrained the department from not to do any some act.
Okay. Against that the department has filed a revision before the sessions judge.
Yes.
Saying what? That this order should be set aside. Simple, okay?
Yes, this order should be set aside. While hearing the matter, Sessions Court asked the department to file some documents with relation to the matter, subject matter.
This is where I have my doubts. A revision is the job of the sessions judge in a revision is to see
Only to see the correctness of the
of that order. How can the sessions judge add fresh material to it?
So
If
because,
they not because Leo, the question is of law, whether the sessions judge can add fresh material to the revision in order to find out whether the trial court's order should be sustained or not sustained.
yes, sir, what Sessions Court asked basically, while hearing the matter, Sessions Court has not stayed the order, and department has proceeded ahead with the act which they were prohibited from not to do.
That
They
contempt
have
would lie.
proceeded.
That contempt would lie.
That is why Sessions Court asked them to file those documents. Whether you have proceeded or not, Sessions Court asked some particular documents.
No, but you are the aggrieved man. Why should the judge look for your evidence? You are the aggrieved man. You have to
That's
show
what
to
I'm
the.
saying now, department, in order to avoid that, they are filing application for withdrawal of the criminal this revision.
Why can't it be allowed? I don't understand. That means trial court's order will stand.
Yes,
According to you, they have violated the trial court order. Is that what you are saying?
yes, sir.
Then you can file a contempt even before the trial court?
Yes,
And the trial court will also ask for the same documents if you are establishing violation of the court order on the basis of those documents, or you obtain those documents under RTI and file it along with your application.
sure, sir.
हाँ,
So
मेरी
now I will. Yes.
मेरी बात समझ गए ना आप?
जी सर, जी सर.
चलिए ठीक है, चलिए आगे.
Now I will take the liberty of asking the question.
अरे ये क्वेश्चन तो मुझे अपने कानून के पूछते हैं जो इनको दिक्कत है.
जी, बिल्कुल.
मेरे को तो they reduced me to giving opinions.
It's very
आपने मुझको कुछ और बोला तो मुझे ओपिनियन दे रहे हैं यहाँ पर.
Sir, now coming back to the topic, just to stick to the topic, I would ask you, what should be the reading routine and what all readings are necessary for someone who has just left college and has started practice? What readings are necessary and what should be the content of those readings ideally?
Readings पढ़ना क्या चाहिए उसे?
जी 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 जी.
This is simple, it is basic. Law college studies are different. The law college does not teach you all the laws. I understand the job of a law college is only to create that legal approach in understanding of the human affairs. The job of the law college is to make you, or I'll put it differently, the job of the law college is to acquaint you with legal concepts rules, regulations, whether they be under the Constitution or they are under statutory law. But it is impossible for a law college to teach you all the laws as are passed by a legislature. So you must understand in law college, they help you. They help you to grow in what we call in understanding the legalities of any situation. They help you to grow that what is this field of law? What is this kingdom of law? What do we call this legal system? What is this court? What is this advocate's job? What is the job of a judge? All these things. Now, how do you resolve the disputes? How many laws apply? That is the job of the law college. And once you are out of the law college, first thing you need to know is that the city or the place or the state where you are practicing, in addition to the laws which you have already, studies or you have become aware of in the law school, you need to buy books in order to understand what is the total number of laws which are currently applicable in the place where you are practicing, whether it is Delhi, Srinagar, Jammu, wherever it is. What kind of laws are applicable? There are laws which are generally applicable, there are laws which are specifically applicable to those areas. To have that awareness, you got to buy the books. I always advise the junior that you must buy those J&K laws. There used to be volumes, about 27 or 30 volumes. You got to buy them. They are not very expensive. The 10,000 or 11,000 they used to sell them for. And buy them, and every day in the evening after you come from the court, you must have a look at the law and also have idea. It is impossible for any person to understand one single law in depth in the beginning, but you must have some idea. For example, you are dealing with land, you must have an idea what are the laws dealing with land. You are dealing with property, so you must know what are the laws dealing with properties. Now you have an idea, I have to go to the court. You must have some idea what are the laws dealing with the jurisdiction of the courts. So similarly, you have a lot of laws applicable like that. But if you every day read one law and try to memorize and understand what does this law deal with, it is extremely important. Coming back to my earlier example, I said whenever you get a brief, too many laws apply. So if you know at least how many laws would be applicable to a fact situation, and you have already read them, so you will have some idea. Again, I say not in depth, but you will have some idea that this law would also be applicable, that law would also be applicable, this law would also be applicable. So you are narrowing your area of research, and you are able to identify that how many laws you have to understand and study. That is what I would say is point number one. Point number two, we have two kinds of laws, what we call the procedural law and the substantive law. Then you have to understand, let's say talk of CPC, you have to understand in the CPC what does it deal with. There's a technique of reading that. You must always look at the contents. When you hold a book on CPC, look at its contents. Then in the contents you will see it is extension. Is it a law consolidating the civil law, or is it one of those civil laws? Then it deals with how to write a petition, what should be written in a petition. It deals with how the response of the defendant would be. It deals with which court will have jurisdiction. Then you understand how many types of jurisdiction are there: subject matter jurisdiction, territorial jurisdiction, financial jurisdiction. You understand that. Then there are procedural part. If somebody dies, what is to be done? Have you to apply for legal representatives in all the cases? That way, in all of the question whether the right involved is right in rem or right in personam. If it is right in personam, no legal representative needs to be brought on record. So therefore, so on and so forth. Then also, while the case is pending, what kind of reliefs you can get till the case is decided by the court, whether it is receivership, whether it is stay order, whether it is any other kind of an order. Which are the provisions which deal with such issues? You need to be aware, and then you see this procedural part deals with it. Also keep in mind that there are laws which do not only deal with procedure, though the name given is Civil Procedure Code. It does not deal only with procedures, it also deals with substantive law. And I think I mentioned it earlier also, Look at section 9 of the CPC. It says that you can go to the court for a civil right, but it does not define what is a civil right. That's a substantive law. And there are so many situations which arise. I mean, something like this. For example, there is a priest in a temple. He is removed as a priest. He says, I have a right to be priest. So first question would be, is it a civil right? Now this will be answered by section 9 of the CPC. That will help you to determine what are civil rights. How does the law, the courts have interpreted this expression civil rights. So therefore the same procedural law also contains provisions of substantive nature. So therefore, having become aware of this will help you a long way in understanding what the law is and what does it deal with. Then you see other cognate law. For example, take this example of stay orders. Then you say, okay, stay order is in order 39. Is there any other law which deals with stay orders? So if you have already read Specific Relief Act, you find yes, there are provisions Specific Relief Act also. Then you see what is the connection between the two. That's the real work you have to do. That's how you translate your theoretical knowledge into practical knowledge. That's how you understand coordination of the various laws. But it presupposes, I'm assuming that you are aware of the existence of these laws. If you're not basically, it's very simple. If you're not aware there is a law like Specific Relief Act, then how would you connect it with Specific Relief Act? Awareness of the law is extremely important in practice. And also the number of laws which are applicable to a fact situation, the case you're dealing with, is extremely important. And in any particular case which you are dealing, you have to see the procedural aspect, which involves jurisdiction, financial, pecuniary, territorials, all those procedural questions. Then also involves substantive, even if you are procedurally, you have complied with all the procedure. Then substantive law, what would be the substantive law? What kind of a right you are claiming? Now then again you have a problem many a times where the right is to be first established. Not that you presuppose you have a right. You have to establish the right first. That's why you seek the relief of declaration. Please declare that I possess this right. After declaration, yes, you possess this right, then comes the other reliefs, which will follow as what we call as consequentially to this declaration. But where the right itself is not in dispute. Say, for example, you file a case, sir, defendant owes me 10 rupees. You are asking the court, please direct him to give me the 10 rupees. Now the defendant comes, he says, yes, sir, I owed him 10 rupees, but I have paid him. Now it does not determine the right that whether are you entitled to the recovery of 10 rupees or not. It doesn't require that, because that part is admitted. What is sought to be set up as a defense is that I do not owe him any longer because I have paid him. So the controversy before the court will only be this, whether the defendant has paid that 10 rupees to the plaintiff or not. So therefore you need to understand in every case where the right is not in controversy. If the right is in controversy, you have to first get that right established. Where the right is not in controversy, then you have to enforce that right, provided you have a right. This is also another aspect. Right. Now see how I connect it with another thing. What is a right? If I ask any of your participants, there comes the jurisprudence. You have to understand what is a right. A legally recognized interest, says the sermon on jurisprudence. So you have to understand that, oh, this right is recognized by law. Therefore it is right. There are many rights which are not recognized by law. I can give you many examples of that. Are you getting me what I am saying?
Yes, yes. Yes,
So
sir.
these are the some fundamentals which this junior advocate has to understand, learn while he is a member of the Bar Association.
Yes.
When he does that, then obviously he is equipped to handle a case. The client will trust him that you handle my case. Now this you have to establish and prove. Now how do you do that? Remember always, I can tell you something based on my own experiences as well. When in my initial years of practice, I used to get sometimes what we call as private complaint, criminal private complaint. Now that involves the question, is it a summons case? Is it a warrant case? One has to read that. What is the procedure to be adopted by the court under CRPC? One has to read that.
Yes.
Now, when you are aware of this, then you are also to be aware of it. How do you write a complaint? What are the material facts which are to be pleaded in a complaint? What are the, we call it factual ingredients of the substantive offense which are to be pleaded in the complaint?
Yes.
Then what are the witnesses? Which witness will prove what is a part of your complaint? This is before you step into the court. You got to think all this. And after lodging the complaint, what procedure the court is required to follow? You have to assist the court. Sir, it's a summons case, please follow summons procedure. No, sir, it's a warrant case, please follow the warrant procedure. That's where your assistance comes in. And then, of course, by evidence, you have to prove whatever you have said in your complaint. Now, this is the something you have to do before you enter the court premises. Something where you are translating your legal knowledge. Write down on the paper. And taking that paper, what you call as a complaint, contains the facts as have actually happened in reality and which are disclosed to you by your client. If he does not disclose all the facts, obviously client will suffer. But it is also a part of my experience. Clients are simple people. They do not know from legal angle which fact is important, what we call as material fact, and which fact is not important.
No.
So you have to extract that information from them. Okay, get this document, get this, what happened at that time. After you get all the relevant facts which you know, since you are aware of the law, you know the factual requirements of law. Therefore, you extract that information by him gradually and slowly. If he has to get a paper, ask him to get that paper which you think is from legal angle important. After doing that, then you prepare the complaint and then go to the court. And I'm sure that you will be more confident because you have already researched and found what you have written in the paper. Then, of course, you can pursue the case accordingly. So this is where you do what you said earlier, where you do becoming aware of the laws, application of the laws, then how you actually translate them. Similarly is the case in suit. Requirements of suit are different. It is a government, Section 80 CPC. You have to be aware of it. If you are not aware at all of Section 80 CPC, you straightway file a case. You don't plead urgency. You don't plead anything. The suit has to be dismissed. Like in a suit for passive performance of the contract, you have to necessarily say that I have always been ready and willing to perform my part of the contract. If you don't say so, the suit will get dismissed. So even before you draft the suit, you got to understand what laws will apply, which courts have considered to be mandatory. That's why what I said, the law in practice. You are translating by writing this plaint, by writing this complaint. You are actually translating what you studied in the law school or what you will study otherwise.
True, sir.
Yes, tell me.
So, sir, my specific question, in follow-up to that would be that it is true that one has to have a grip on the statutory law, but other than statutory law, developments.
What else should be there?
Developments take place every day by way of precedents or case laws, and the body of case laws is so huge that once a new entrant to the field comes, he finds it very difficult to keep track of the developments of law or interpretations given
He
by
should not
government.
find it difficult. I don't think, but only question is whether he is willing to work hard. First of all, you must subscribe to AIR. Whether you have a case or you don't have a case, some amount is to be spent. I don't know, I used to spend those days, it was 10 or 15 rupees, now it may be 100 or 200 rupees or 300 rupees. When you get this monthly AIR, now it has the judgments of Supreme Court, it has the judgments of High Courts. Now you may not have a case at all, but make it a habit to read it. Read the judgment of the Supreme Court. Now the advantages of reading. One is it will improve your language. Some of the judges write very beautiful. It will improve your language. One, you will be introduced to the new words which you have never heard before. Number three, there are a lot of Latin words used in our laws. So you will become aware of the Latin words. Number three. Number four, then you will look at the judgment and see the structure of the judgment. How does the judge arrive at a conclusion? You will find two things in that. One, there are some fundamental premises in the judgment which are unquestionable. On that premises, the judge builds up the case. He will never build up a case on controversial premises, is the third thing you will use. Number fourth, then you will see how has the judge decided the case, meaning thereby how has he done justice to the parties which were before him. Has he done justice? We call it according to law. Simply the law says walk on the left side of the road. The judge finds you have not walked on the left side of the road, therefore your case is dismissed. Or the judge has found a way, whether it is in equity, whether it is in what you call good conscience, whether judge has found a way of doing justice. Do you understand?
Yes.
So therefore, when you read a judgment, it is not simply reading English language. It's a study to understand, should I put it more in depth, thought process of the judge. He expresses himself by the words he uses. Is he superficially writing? I mean, just like the cow has 4 legs, 1 tail, 2 eyes, that is also a method of writing. But is he writing it differently, the same set of facts? And how does he deal with those set of facts in order to arrive at a legal conclusion? So when you read this judgment, then also there are advocates who have extremely good memories, they remember it. Then there are advocates who may not, it's impossible to remember 20 lakh judgments. In olden days, we used to have one register where we would find that this judgment may be useful. This judgment may be useful. I will give a simple example. One of the pet arguments of the lawyers is when they apply for stay. When they apply for stay, the opposite lawyer will tell the judge, sir, if you grant interim stay, it means granting the main relief. So therefore don't grant the stay, is an argument. Then there are judgments saying the court cannot grant by way of interim relief the final relief. So you will lose the case. But there are also judgments which says that depending upon the facts and circumstances of a case, the judge can pass an interim order even if it means granting the final relief. Understand? So you find when you read these judgments, apparently you may find them contradictory, but they are not contradictory. But they deal with a certain fact situation which has arisen before the court. Because the court understands, like demolition of a house. You say municipality has no jurisdiction to demolish my house. If you don't get the stay, the house will be demolished.
Yes.
Now, the municipal lawyer says, sir, if you grant the stay, it means granting the main relief.
Understood.
In his own way, he is correct.
He is
But then
right.
you have a different answer. Okay?
Yes, sir.
So that is how it is. So when you are in a court, when you ask this question, in my opinion, what you need to do is that you buy this AIR, read the decision of the Supreme Court. You may not be dealing with a murder case immediately. You may not be dealing with income tax matter. You may not be dealing with excise matter. There are judgments also delivered by the court on that. But it's extremely good that if you become slightly aware of that as well.
True.
Okay? And
Yes,
at
yes.
home, keep the register in which you find that these judgments are useful.
Yes.
Yes, tell me.
Which is maintaining the case.
Now it is done now through, you have these digital systems. If you are good at it, you can do it on digital system as well.
But in my experience, sir, one has to come back to the paper and pen at the
Yeah,
end of the day.
I am also of that view. I was telling your friends here that maybe I'm old fashioned. I like a book holding in my hand, turning the pages. Like a poet, they say that fragrance of that leaf is so good to you.
Yes.
But that apart, all my life I haven't seen the books, and I found it is good for my eyes. My eyes don't get tired because they're always looking at these computer screens all the time. You get tiredness in your eyes. Yes. You can't do that. I mean, it's so not so good. But in any case, it varies from person to person, wherever you feel comfortable. But whole the idea is that you must read it, make it a habit every day. You see, I'll tell you like this: every day, if you read one single judgment, in 30 days, because these AIRs are issued after every 1 month, you will read 30 good decisions. Improve yourself, improve your language, improve the structure of your arguments. See how the judges decide. All over the world, if you have that much of time, you read the foreign decisions also. See the English decision and see how they decide. How they go into the nuances of each and every word which is used in the text.
True, sir.
They understand that also.
So, from a personal experience, once someone starts reading a journal, there's also always something which we youngsters would call fear of missing out, because there are a lot of judgments in too lesser time to read all of them. And there's always this feeling that you have missed some important case laws, you missed reading some important case laws. So, how does one go about that?
I couldn't get your question. When you said that when you read a judgment.
When we start reading journals every month, sir,
Uh-huh.
so obviously it is not humanly possible to read the entire journal or all the case laws which are reported in that for that month.
No, but I told you, you read 30 per month, one day, one judgment. There are small judgment, there are big judgment. If you read case one of the Bharti's case, maybe 1700 pages. I can understand you take 10 days.
Yes.
But if you take a 2-page judgment, 3-page, what is the problem? What have you to do after 4 o'clock? After 5 o'clock? Watch television?
No.
Go out with girlfriends or what? Go and read, sit on your chair, on a desk in your home, work hard.
Yes.
You have to listen to me. Nothing comes for free. In the sense that you have to put in your labor. You have to sacrifice lot of your temptations. Lot of many things are to be sacrificed. This is a highly demanding profession, highly demanding, and it's a demand on your time. Today, when I am talking to you, my race is against time. I was doing this 370 case in Supreme Court. You won't believe it. This full month which I was stayed in Delhi, I was sleeping with 370, getting up in the morning with 370, washroom 370, talking 370. It got on my nerves. You get obsessed with it because you are thinking all the time about it. That is the job of a lawyer. Then you can have an extremely good presentation in a court. It's not otherwise possible to have presentation no. Yeah, one more thing I want to tell you. There are laws which do not answer the problem which you are facing, but yet you want the judge to accept. Now I will use the word, not the law which you are saying, but accept your viewpoint. So you need a tremendous power of persuasion.
Persuasion. True, sir.
How do you get the power of persuasion? For that, you have to do other than these AIRs and SECs and criminal law journals, other than legal journals, you have to do extra study, which is very, very important. Extra study would mean read philosophers and look at the way they think and observe the world. Read the literature. If you are good at poetry, read poetry and see how the artist, how the poet in few words will capture a world of ideas. This will also help you to grow. Then there are laws, I think I mentioned to you sometime, which deal with economics, like we have the Surface Act.
Yes, sir.
It deals with economics. So you have to understand what is a capital receipt, what is an expenditure receipt. It will help you in income tax also. Now you might say, I don't know. You have to buy the book to understand what these expressions mean.
Yes.
Meaning thereby that you must go in for extra study.
True.
Therefore, in addition to the criminal law journal, maybe on a Sunday, maybe on a Saturday, you got to read it and improve yourself constantly. It is a legal study is a work in progress.
That's true. Forever, sir. Yes, that's true.
Till you step into the grave, you are a student. You go on reading, one other views change. I mean, even in law school, they teach you, for example, famous case of this fundamental right where the parliament will have the jury. How many judgments are delivered? One judge said, yes, parliament has the power to amend them. Another group of judges said, no, it does not have the power to amend them. Third came up, no, they cannot amend the basic feature of the constitution. This is the growth and development of law. So somebody has worked hard on it. Somebody has found answers to these questions, which are not otherwise answered by simple section. Show me the section. It makes no sense anymore. Show me the section.
That's true, sir. That's true. So,
So,
it's a learning in process, and of course, there's no debate in learning and reading at all in this
and,
profession.
it's a very beautiful journey.
That's
Learning is a beautiful journey. It will make you a learned man.
so
We
that
call
is
you
the
learned
reason
counsel.
we're all here.
I said we call you learned counsel in a court of law. But you have to be learned in the real sense of the word, not that in a routine manner.
Now we'll open up this for other people to ask questions
Ah,
as
they
well.
are not asking any questions, they are asking me legal opinions.
Mr. Tausif, Mr.
Come on,
Tausif.
come on, come on, ask me a question, don't ask me opinions. Tell me. Any
Mr. Tausif,
gentleman?
please unmute yourself.
Walaikum sir.
Walaikum assalam, boliye Momin sahab.
Sir, this is Tawseef Manzoor, but not
Oh,
Mohammed.
but Tausif, you have a beautiful photograph, I see.
Sir, thank you so much, sir.
Okay, tell me.
Sir, basically, I also need a suggestion or rather a question. Basically, I am stuck in a case. Person A is the owner of a car.
Yes.
Not person A has purchased a car from a car dealer.
Correct.
Fine. Then the car dealer somehow he is not getting in contact with the owner of the car and has failed to transfer the car to the person to whom he has sold. Fine. The person with whom the possession of car lies right now, he filed a criminal complaint before the court of city judge, wherein he has arraigned that car dealer as an accuser number one and owner as an accuser number two, wherein he is before the court praying that they be directed to transfer the vehicle in my name. Whereas I am representing the car owner. Like, I have no direct contact neither with the car dealer, neither with the petitioner. That is to whom the possession lies with the petitioner. Now I fail to understand here.
What was your, I have got your question. What was your role? You are a car dealer only. You are not the owner.
No,
You
no,
are
sir.
a,
I am the car owner. I have sold it to person B. He is from my same lobby. Fine, sir. But then the sale continues for 6 persons, and ultimately it landed in car dealer's shop. He further sold it to person A. That person A is right now claiming, but he has arraigned me as a party. Whereas I neither know the car dealer, I neither know the person with whom the car
No,
lies
I-
right
just
now.
wait, let
So
me- let-
what is the remedy for me?
Yeah.
I have been pleaded as a party in a criminal complaint before court of city judge.
yes. Let me get the facts clearly first. When you are using the word owner, your car
Yes.
dealer is the owner in terms of the provisions of the Motor Vehicles Act. He is registered owner. Say yes or no.
Car dealer is not the registered owner. I
So
am the
then
registered owner.
don't use the word he is the owner.
Sir,
Who is the registered owner of the vehicle? Somebody has to be registered owner of the vehicle.
my client is the registered owner of the vehicle.
Now your client, but you said you represent the car dealer.
No, sir. No, you are, sir. But I am not representing. The person who is the complainant has arraigned car dealer as well as myself, as I am the counsel for the owner of the car. I am be also implicated as a party. Whether I neither know the accuser number one, I neither know the petitioner in the case.
No, other two
That is my-
arguments leave aside whether you know them or not. I'm asking a simple question. Who is the registered owner? Go to the fundamental.
I am the registered owner, sir.
Now, number one, okay, you are the registered owner, okay?
Yes, sir.
Now, you have sold this car to Mr. A or B or C.
Yes, sir.
You have sold this car to A or B or C.
I have told it to person A, yes, sir.
Okay, now what kind of a documentation you executed with him?
At that time, it was verbal because he was working in my firm.
So there is no documentation. Say like that. There is no documentation.
documentation. He owes me some money. I told him, you give me that
No,
money, I will transfer
that is the other moral side of it. But so far
Sir.
as the laws are concerned, according to
Sir.
you sold this car to him, but you did not execute any document with him.
Not at all, sir.
Yes, number two. Number three, but you did receive part of the money from him.
I received part of the money.
Yes, number
and some
three.
part
Let,
in-
let us
yes.
go to the material facts. Now, remaining money he did not give you.
No, sir.
Okay. Number five. Therefore, you continue to be the registered owner.
Yes, sir.
Now, this person to whom you sold the car, he
Yes,
has
sir.
lodged this complaint saying that they must execute the transfer documents in his favor. Is that right or
No,
wrong?
no, sir.
Then,
The person I have sold the car, he has sold it to many persons, A, B, C, D, E, F. Fine.
all right.
Finally, it has reached to car dealer.
No, but
Sir.
when this gentleman to whom you sold the car, but
Yes, sir.
without any transfer documents,
Yes, sir.
in law you will continue to be the registered owner of the car. In law, in
True,
fact,
sir.
you might have handed over to somebody like you give a car to your friend,
Sir.
but he doesn't become the owner. In law, the registered owner continues to be the owner. Point number one. Point
True,
number
sir.
two, the person to whom you gave the car and
True,
received part consideration, he has
sir.
in turn transferred this car to somebody else.
Sir, truly.
But with correct, is that correct?
Yes, sir, absolutely.
And that person to whom he transferred, he must have received some money from him.
Undoubtedly, sir.
Right? But he must not have executed any document in his favor.
True, sir.
Because he himself is not the owner, what kind of a document he could give?
True, sir.
And there is also law, you cannot pass a better title than what you yourself possess. Since you do
True,
not
sir.
have a title to the car at all, you cannot transfer the title of the car to the subsequent purchaser, correct? Then
True,
that
sir.
person again sold it like this.
Absolutely,
In
sir.
Kashmiri we call it hushmush sales, without any
Yes, sir.
legalities. The answer
sir.
of law is different.
Sir.
This is not the answer of law. He sold A, B, C, D. The answer of
Sir.
law is this, that you are a registered owner
True, sir.
and you have received money from A.
Yes, sir.
That person, if you are honest enough to say, yes, sir, I received part consideration and I am
Yes, sir.
willing to transfer this car as a registered owner. I
Yes,
am
sir.
willing to transfer this car to this purchaser, let him pay the balance amount. That is one situation. Second
sir.
situation is this person cannot claim because there is no document in his favor
True, sir.
showing that you have agreed to sell the car to him.
True, sir.
So he will seek enforcement of which right? He has no right, there is no document. Take the
True,
other
sir.
way. For example, you deny. You said, no, sir, he is wrong. I have not sold this car to him at all. I continue to be the registered owner. What is the proof with him? None.
Nothing, sir.
There is no proof with him. He will
True,
suffer
sir.
for want of evidence. So,
True, sir.
therefore, in the law, the answer is this, that if you are appearing on behalf of the registered owner, you will
True, sir.
continue to be the owner in law, not in fact. Which
True,
you,
sir.
the facts you told me, you will continue to be the owner in law. The person
sir.
who has lodged a complaint against you cannot succeed. Now, tell me, has he lodged a criminal complaint or a civil case?
He has lodged a criminal complaint and court has taken cognizance. Also, warrants came to be issued against me and then
Now,
I
in,
appeared before
in
the
criminal
court.
complaint, what does he say?
He says that they be directed to the owner be directed to transfer the vehicle into my name and also directed.
How can a criminal court only sends a person to jail? Criminal court cannot direct that you execute the document. This is a pressure tactic used by. This is sheer
I think
abuse,
we
sheer
should leave
abuse
the
of
topic
authority.
here. I think we should leave.
May I ask a question? Am I audible?
Yes, Mr. Asif, but I will request
Must-
nothing about your case.
Kindly. Am I audible?
Yes, Asif Saab. Yes.
Assalamu alaikum.
Walaikum
I'm
assalam.
Advocate Asif Khan from Sopor. Sir, my question lies in your past. Sir, you visited university between 2012 to 2014, if I am correct.
Who, me?
I ask between 2012 and 2014.
You are,
I was pursuing law there.
okay.
So since the topic is on law in practice,
Huh.
it's a very Herculean task to tackle for a law graduate when he passed out and joins the law in practice. Sir, we read there it's bail bonds and यहाँ पे मुचलक होते हैं. So if one is not acquainted or familiar with the Urdu, has to tackle that situation here, sir.
Yes,
Sir,
but you will pick it up. I also did not pick it up, but then you learn that is
Yes,
muchlaka is the
yes, sir.
same as
I'm
bail
talking
bond.
in general,
Okay,
sir. I am well acquainted with the Urdu, sir.
good,
Kindly,
good.
my question is, sir, once you disclose there that you have a good friend, businessman, and I will not disclose the name of that friend. So you told him that I have a money and I want to invest in business since you are well established businessman. So where should I invest? So your friend suggested you are the intellectual of the society. You should not invest in business or hotels or something else. because you are called Zaffar Sir, then you will be tagged something else, Zaffar hotelier. I stand sincerely apologize or technically apologize for the fact if I have erred in that, sir. Then he suggested you, sir, that you should open some institute or some library, and sir, you disclosed that I am intended to open an institute whereby the law graduates will pass over. Then I will teach them how law is in practice for 3 years or 2 years or 1 year internship will be given there, and they will join the law in practice, and they will not the impediments which are faced by the newcomers who are new in practice.
Yes.
So that will be taken over, sir.
Yes.
Kindly.
First part that he suggested is not correct. This was my own personal decision because I have my own moral reason. That is the society which gives you respect, the society which gives you money. At some stage in your life, you have to return it back to the society. That is the philosophy and the value which I have. Point number one. Point number two, having regard to the long years of practice, I felt that I have a duty to the society. And what is the nature of that duty? The duty was not to set up a hotel. The duty was not to do business, because the primary and the dominant purpose of doing business is to make money. And at this stage, when you are established, your children are married, you don't need much of money at all. And the doctor will also advise you don't eat too much, eat less. So there is no occasion for you to spend money. Third thing, that as I told you, you need to do, we all must think. I'm not talking about myself, but I'm sharing this view with you. You must help your people, you must help your community, you must help the people where you live, where you stay. Now the question is, how do you help them? Since I'm a lawyer and I practiced for so many years, then I thought to myself that it is again based on my observation that when young lawyers come to the court, they lack confidence. Point number one. Point number two, they lack that fluency, their language is true. Number three, they are not able to translate lot of thoughts into the language which they speak in the court. Number four, they are not very good at the use of the words in the court. Number five, they do not understand the logic, they do not understand the persuasiveness, they do not understand the how to join the dots in a particular case. All these things I have noticed among them. So I thought that there must be, this is a kind of a gap which exists, and this is not taught even in the law schools. So I thought that if I open an, whether you call it academy or some kind of a center, where I felt that I could share my views, not only my views, I have my definite plans. I will invite all the retired judges of the High Court, maybe of Supreme Court, to come and interact with maybe 10 or 20 lawyers. I will have a program set out for them for 1 month, 2 months, or 3 months, where they will come at 4 o'clock, join the class, and then we'll teach them. Developing their personality, their confidence in themselves, legal knowledge, and so on and so forth. Then I also felt that will be also be a research center, because now the time has come for researches. In our days, we used to be one lawyer and one clerk with him. Those days are over. In my recent experience in Supreme Court in 370, I noticed that every senior lawyer had 3-4 juniors with him who had done research for him, and they were extremely good at these devices what you use now. So therefore, I felt they need to be acquainted with the use of these devices. In fact, the Chief Justice of India also does not like paperwork anymore. He likes you to argue on the basis of iPads. So this is second aspect. Third aspect was, this was something my return to the society, to till Allah gives me the life, I will try to help my society. This is what I felt. Now, when I told the second part, it was his idea. No, it was always my idea, and I have said so earlier also in my Facebook. Also, if you see 4 or 5 years back, I said this was in my mind. But now, since it takes a lot of money to establish, I'm in the process of making the building. I'm trying to sell some of my properties, but I have difficulty in selling them. But let us see what Allah has in store for me. Inshallah, I will have this legal academy. While invite your lawyers. Yes.
Those impediments will come over, because I would like to say only one couplet for that. अकेले निकले थे हम जानिबे मंजिल, मगर लोग आते गए, कारवां बनता गया. जब आप निकलेंगे सर, लोग आपको
Inshallah, I mean आपकी बात पे I wish that तो मेरा ये कहने का मतलब है वो इसलिए बिजनेस करना, देन मेरे में और बिजनेसमैन में क्या फ़र्क रहा, मुझे इतना बता दीजिए। ये जो कानून का इल्म हासिल किया, इतनी मेहनत ज़िंदगी भर की, इतना पढ़ा, इतनी लाइब्रेरियाँ बनाई, इतना सब कुछ किया, ये किस काम किया कि बिजनेस कर रहा था पैसे बनाने के लिए, मैं पहले ही दिन करता।
Right, sir.
मुझे 40-50 साल क्या करना था इस कोर्ट में मगजमारी।
Right,
इज
sir.
एज सिंपल एज दैट। लेकिन थॉट्स जो आपके हैं वो आपके होने चाहिए करेक्ट। यस।
Thanks for answering.
Members have sent in-call messages as well. So we'll take a question.
वालेकुम अस्सलाम जी, बोलिए।
Good evening, sir.
गुड इवनिंग, गुड इवनिंग।
Good evening, speaker. Good evening, honorable speaker, sir. Senior advocate, sir.
हाँ बोलिए।
Sir, I am Arjun Chawla, law student, 3 years, studying in 6th semester.
करेक्ट।
Sir, basically, our criminal law says that the prospective accused has no locus standi to participate in a hearing before the issuance of process. So, be it 156, 340, 202, or any other enactment. Sir, my question is that if in a certain proceedings, the false affidavit has been given, apart from the perjury application, if we make an application to the court under section 15(2) of the Contempt of Court Act, whether the court can say that he is bound to hear the prospective accused before referring a criminal contempt to the Honorable J&K High Court, to the division bench for taking cognizance. When the J&K Contempt of Court rules makes it a provision to hear the prospective accused also in a preliminary inquiry. But sir, if we examine those rules in view of the 15(1), even in case of Kunal Kamra's case, when Attorney General issued the reference, he didn't put the Kunal Kamra under notice. So my question is that whether at this stage the information has to be tested by doubting his correctness or credibility, when the information clearly says that there is no discretion to hold the information or to check the correctness or the veracity of the disclosure of it. Basically, the trial has to be conducted by Honorable High Court by way of either taking affidavits on supplementary, by way of evidence affidavits over there. But whether the subordinate court can expand the scope of reference by asking the other side to file reply and argue on the matter why reference should not be made to Honorable High Court.
I'm
Because this is just an information, sir.
no, I understand.
Let Mr. Shah answer.
What I understand from you is, number one, you're talking of a prospective accused. A person is not legally as yet an accused, but you say that person should be allowed to participate in the proceedings. Before that, there is more fundamental question. When you talk of a criminal case, in a criminal case, it is necessary that the court of competent jurisdiction takes cognizance. Now, cognizance means cognizance of an offense. It means that offense should be committed. This is issue number one. Issue number two, when an offense is committed, the second question is who has committed that offense. Now, when you file a criminal complaint before a trial court and the trial court has not taken cognizance, meaning thereby that the trial court is not satisfied on the basis of true or false affidavit or on the basis of documents, the trial court has yet to evaluate the material existing on record in order to arrive at the conclusion that some offense is made out or not, and is that offense cognizable or not, or is it a non-cognizable. That power, that absolute power vests in the trial court. So when a complaint is lodged and the trial court has not yet taken any cognizance, why should the accused go and tell the judge, look here sir, I am ready to hear and assess the court that this complaint should be dismissed because this is false. The court's answer is very simple and correctly so. Look here, I have not made you an accused as yet. Becoming an accused is extremely important. Before that, he might give 10 false affidavits as a complainant. He must speak 10 lies. It is for the judge to evaluate the lies, the affidavits, the statement of witnesses recorded at the time of lodging of the complaint. It is exclusive jurisdiction of this court. This is one aspect. Second aspect is, I am not able to get you. You said reference is made by the trial court to the high court. Reference for what? Yes, gentleman. Yes, Mr. Arjun. गायब हो गया.
Sir, references regarding, for example, if I have given a false affidavit in a certain proceedings, now I moved another application for making a contempt reference to Honorable High Court under section 15(2) of
Wait. You are jumping too many things. Number one, First, you gave me that set of facts in which I am of the opinion that there is nothing like prospect to accuse. How do you know you may or may not be accused? That is for the judge to say. Point number
For
one.
example, I have given an affidavit that I am not in possession of sufficient means to execute the decree, and the court has directed me to give the property details under Order 21, Rule 41 CPC, and I furnish the properties which are not actually belonging to the judgment debtor. So I am giving someone's property and I am giving incomplete details, which is creating an offense under Section 206 IPC. So my question
No,
is
no.
that
No. You jumped at a few more things. Are you talking of a civil matter? No, I am not getting the
yes,
facts
yes,
from you.
I am talking about a civil matter in an execution of decree, sir.
Slowly. I will narrate the facts. You tell me yes or no only.
Yes, sir.
Now, there is a decree which is sought to be executed.
Yes, sir. Yes, sir.
In that decree, the decree holder has applied for attachment of the property of the judgment debtor. Is that correct?
Decree holder has applied for only execution, but in an proceeding, the order has been passed under Order 21, Rule 41, directing the JD to submit a list of movable property.
Obviously, it means when you apply for execution, the court has several options under Order 21. One of the options is this: if this is a money decree and money is to be paid, assuming, for example, and this person, judgment debtor, has not paid the money, now money is to be recovered from the property of the judgment debtor. Okay?
Absolutely correct.
Now, how does the court know what property he owns? It is the duty of the decree holder to inform the court about the property which, in the opinion of the decree holder, belong to the judgment debtor. In that, this is possibility that he might indicate a property which does not belong to judgment debtor, but according to the information of the decree holder, it belongs to judgment debtor. So he gives a list of the properties which, in his opinion, whose opinion? Decree holder's opinion, that property belongs to judgment debtor, and he gives a list of those properties. The court believes that list on the basis of the material provided by the decree holder and proceeds and directs attachment of the property. Now, when the court does that, then the persons who are the real owners of the property, they have a right under Order 21 itself to approach the same court and tell the court that these properties, the list has been given by decree holder, do not belong to him. They will have to produce that necessary material to show that these properties do not belong at all to the decree holder. Now, what is the question of making a reference for what false affidavit? He will say that according to my knowledge, they belong to him. Have I understood you correctly or no?
My submission is, sir, actually they have filed an affidavit in which they have stated, first of all, they are not in possession of sufficient means to execute the
Who has just wait. Who has filed this affidavit? Judgment debtor or decree holder?
Representatives of the judgment debtor. And according to the documents which are available to me, they are having sufficient means to execute the decree. So one statement that they have made under affidavit is wrong, and second statement is that they have mentioned 3 properties.
Wait. I have just don't jump. I understand. What you are saying is the first affidavit was filed by judgment debtor that they do not own any property. Is that correct?
Yes.
Then the decree holder furnished the list of the properties owned by judgment debtor. Is that correct?
Yes, sir. Yes, sir.
Now, what are you saying? Obviously, the first, if the court is satisfied, if the court is satisfied that what decree holder has said correctly, then obviously the judgment debtors have sworn a false affidavit. But that will be only possible after the court holds that the judgment debtors have spoken lie, given a false affidavit, because the court records a finding that the judgment debtors do own the property. Is that correct?
Yes, sir. Yes, sir.
Then this very court has the jurisdiction to direct lodging of a complaint for swearing a false affidavit in a judicial proceeding. There are protections available when you speak lie in a court of law. Who can lodge a complaint? You can't sit at home and yourself decide that they have given a false affidavit. No. It is to be done by that very court where the affidavit is filed. That court must first arrive at the conclusion that the affidavit filed is false. Then only that court will direct lodging of the complaint. I think it is It used to be section 479 of CRPC. I don't know what is the new section. That giving false evidence in a judicial proceeding, that court will decide first.
Sir, now we'll take the next question. So Zurain and Iftikhar, who are with you and unfortunately can't ask this question online, have texted the question. The question goes: how do we make sure we stay abreast not only not only knowledge-based pursuits but also in soft skills and practical skills? Meaning, thereby, how do we learn code craft? So, yeah.
No, the two are different. Soft,
These are two
soft
different.
skills is what? Using how to use computer application and all that.
Yes. Yes. Yes.
That you have to learn from a technical expert. What? There is no other method. You're orally or somehow. Yeah. Like
I
I
guess judging by your experience as well.
I'm trying to learn myself how to use it. I had difficulty even in Supreme Court about it, but then I apologize to the Chief Justice. I said the process. Right now I'm talking to you right on this device.
Yes.
So the lady advocate helped me in how to approach you. So it is a time consuming. It is all right. We young people
And
can
he's
understand
the
it
one
far
asking
better
this
than we
question
do.
to you, sir.
No, the first, this question is, of course, you got to learn it, as simple as that. There are no
Yes.
compromises on that. How you learn it, whether you have an expert advice, whether you learn it from your friends, whether you read books on that I leave, how to use the device. Okay?
Yes.
Now the second question is, what is the second question?
About code craft, sir. Code craft.
No,
I mean,
you see, I'll tell you court craft. We use this word court craft, means getting an order somehow. There are advocates who use court craft, there are advocates who do not use. Now, I'll give you a simple example. I remember one advocate, I liked him a lot. His name was Mr. A.K. Sen. He's no longer alive, practicing in Supreme Court. Now, he filed a writ petition in Jammu and Kashmir High Court, and I was sitting in the courtroom. That's what if that is meant by court craft. And the writ petition was that the government had not given subsidy amount to the claimant. So he had filed a case that the government be directed to release the subsidy amount in favor of the claimant, the petitioner. So when he filed that case, obviously it will also come to your mind. It will also come to your mind that court cannot pass a decree saying I hereby direct to pay 10 lakh, 20 lakh or crore rupee to the petitioner. It will be like a decree of a civil court. Now here comes the skill, here comes the command of the language. While the judge was writing the order, the judge was also hesitant in using this word. I hereby direct the government to release so much amount. It was like a decree of a court. He intervened. Now remember this expression. He said, my lords may say that the government is restrained from withholding the amount. This is called, इसको बोलते हैं. अब negative बोलियो, positive बोलियो, important बात वो नहीं है. He said the same thing. If he would have used the words I were directed to pay, you would say, what kind of a judge is he has passed a decree for 10 lakh, 20 lakhs. Now he said that the government should not withhold the amount. इसको आप decree तो नहीं बोलेंगे. Can you use this word?
no.
This is what you call understandings. This is what you call that in a court by appropriate use of language and the words, which I have always insisting are very, very important in a court of law. Like, for example, I think I mentioned it earlier also. You go to the judge, you tell him, sir, please direct the police not to harass me. Now look up for the meaning of the word harass in dictionary. What do you mean by harass? If the policeman looks at you, you say, sir, I am getting harassed. He looked at me, therefore punish him for contempt. This is nonsensical. There will be no contempt. You always try to get an order from the court which is a workable order. Which is a workable order, not orders like this. Like, for example, you say, sir, this man should not come to my office. 100 feet away, he should stay from my office. It is a workable order. So, therefore, the language is important. Then you have to assist the court in passing an order which you think is the order which you need to obtain from the court. So, there, if you are just suggesting to the judge, and which appeal is to the judge, that's what you call this expression using court craft. This is one. And second thing is also, possibly that could also be included in court craft. That is, judges also have their own perception about the cases. Judges also have perception of law, because they are also experienced. They are not newcomers. You become a judge, maybe I'm talking session judge, high court or Supreme Court, after 20, 30 years of being a judicial officer. You also have an impression. So when a case comes before you as a judge, you automatically have that impression. Now I am a lawyer, I want to change that impression. How do I do that?
Persuasion.
Yeah. I have to change your perception. That's why your skill comes in. How do you change that perception of the judge? And in my opinion, you can do it only by first entering into the mind of the judge, not in the physical sense, but intellectually, understanding the perception, and then explaining to him that his perception needs to be readjusted. That perception needs to be readjusted about a particular case, about a fact situation, or about the perception of law. That's where your skill comes in. That's what you call this court craft. You approach the court by looking at it.
Yes.
Yes.
So it's more like reading the mind of the judge before.
Naturally, you have to understand that because he must understand you.
Yes. So the next question, which was submitted by Ms. Sharika, was, my question is, why is the beginning of the legal profession the hardest for first generation lawyers? Why do they have to suffer exploitation from seniors as well as touts? So this is more of a complaint, sir. If you could elaborate on that.
No, I can just simply why to become a junior of somebody first.
True.
Why? Choice is yours. Use call of exploitation. I don't also understand what is the meaning of exploitation. If you say that they're taking work from you without paying you, well, that is the kind of profession it is. Whether he pays you or does not, this is number one. Number two, all over India, at least I know about India, lawyers attend the office of the senior lawyers with a view first to get access to the libraries, access to the briefs, the files, and also if they participate in the discussion, they will understand how the senior advocate is dealing with clients. That's also an art to deal with clients, and then also understanding the pain of the client and how does he find solutions to them. Now, this is in the beginning, he is getting this kind of experience free. A lawyer is not like an employer, but there are juniors who get paid and very well paid. I know that also. But they make themselves indispensable. Now, how do they make themselves indispensable? When there is a case, the junior will listen to the case. He will also listen, he or she will listen to the case and find out what are the issues involved in the case. She or he will of her own go to the library, find answers to those issues. I will give you some example just now also. And then coming up with a written brief to the senior advocate. Sir, in my opinion, these are the issues involved in this case. This is the list of dates. They are experienced a list of dates, how to prepare a list of dates. These are the issues involved and these are the legal judgments supporting the answer in our favor. That helps the senior advocate a lot. It saves his time. It saves a lot of things. So if there he pays, payment gets justified. I was in Supreme Court and one of the senior advocate, Mr. Kapil, had a junior. She was extremely good. Now I'll tell you how. She was holding this eye tablet in her hand. He exactly knew what Mr. Kapil Sibal has to say. Now, if Mr. Kapil Sibal had forgotten something to say, she would tell him, sir, this is also to be stated, without interfering in the proceedings before the court. That is her expertise, because she kept pace with the arguments of her senior, number one. Number two, if Mr. Sibal would refer to a judicial decision, now the system in the Supreme Court is that you give a copy of that judicial decision in advance to the court. Then the court has a PDF number. Now we lawyers, we go by journal paging. There the Chief Justice would go by PDF. He would not go by journal paging. Now then you have to find out the PDF of that journal page which you want to refer. She was extremely good at it. If Mr. Kapil Sibal would refer to a case, she would just tell him, sir, it is PDF number 135. Are you getting me?
Yes.
There you find a space for yourself. You are helping the senior advocate. So senior advocate feels happy that you are helping him, and which is quite a good help. So therefore he doesn't mind paying. But
So at the
third,
end of the day, it's about the value that you add or bring with you.
I don't know, the kind of assistance and the space you find, because seniors don't have much of time. So therefore you find a space for yourself. The senior also gets impressed. But lastly, I will tell you one more thing. I used to remember a nasty phrase They say it is better to be the head of a dog than to be the tail of a lion. Do you understand that?
Yes, sir.
What?
It's
It
better
is,
to be a big fish in a small pond than a small fish in a big pond.
yeah. So you do the case yourself. You may win, you may lose, but you have the personal experience.
True.
And that is how you will grow. If you don't fail, if you don't lose a case, you will not grow. You have to
Sir,
grow.
a personal question in this regard. Who was
Right.
your senior when you started out, or you didn't
No,
have any
no,
senior?
no. I remember somebody told me there was one Mr. Bond those days, and I was with him for 3 months. I mean, the seniors don't take classes. Okay, junior, sit before me, write down the plaint. I mean, nobody will do that. And why should a senior do? That's not his job. You are supposed to learn that in the law school. Okay? He would just go up the stairs, I would go up the stairs with him. He would enter a case, I would stand behind him. It happened for 3 months. Then I knew that if something has to be done, I have to do it myself. Now, how did I do it myself? See, the chances you get in your life. There used to be some colleagues of mine. They were more interested in politics than in law. If they had a case, they have no time to attend the case. So they would tell me that you attend this case. So I got an opportunity to attend the case of somebody else. But I really worked hard in that case. So when I used to work hard in the case and speak in the court, the opponent would also get impressed. I remember a case where I did of a client A many years back. After about 4 or 5 years, the opponent came to me. I told him, hey, no, I can't take your case. He said, no, sir, this is not that case. This is a different case. But I want to engage you. That you grow your reputation where the people watch you. You grow your reputation where you are able to deliver. You grow your reputation where the judge feels that he's a credible lawyer. He's a trustworthy lawyer. You grow yourself when you maintain certain standard in terms of values. You grow yourself when you are honest in giving opinions. You will always have a choice in law. I tell jokingly to somebody, if he gives me a 10 lakh rupees and tell me, make me president of India. I have an option. Honest opinion is I can't make him president of India. But at the same time, I will lose 10 lakh rupees. So if I'm a dishonest lawyer, I'll tell him, don't worry. I'll make you president of India and pocket 10 lakhs. I know that I can't make him. Even howsoever tempted you may be in house of money you may require. You got to be a man of values and extremely honest. That case is good or not good. Yes, if the case is 50%, take it. Then by power of persuasion, you may succeed. But if the case is rotten, it is not a good case at all and you can never succeed. Why to take that case? So therefore, honest opinion, sincerity, honestly working hard, your own credibility, your understanding of issues involved, then your logics, persuasion, knowledge of law, all these things get mixed up. And that alone will help you to progress.
So it's more about personal effort and making your mark by your
It is a personal service, remember always, just like a film actor. You don't have duplicates.
Yes.
Dilip Kumar was Dilip Kumar. You understand? Similarly, the lawyer is Fahad is lawyer. So
Yes, sir.
client comes to Fahad. He doesn't come to your friend. These are you render personal services.
Yes.
Don't forget that. He has come to you.
True, sir.
Firm is your forum for many other purposes. As I told you, infrastructure facilities, these now the new device facilities,
Logistics.
researches, and so many other sort of logistic support. So you do that, but it is essentially these are personal service.
True, sir. So next question is from Mr. Wasim Mushtaq, who is saying, for someone who has just graduated and entered court, just a small question with regard to taking witnesses and art of cross-examination. How do we learn this thing?
Yes, this is quite a relevant question. A lot of people ask. First of all, you can never learn it by books, but you need to have some theoretical knowledge of the Evidence Act. When we say this fact is established, what do we mean by the word this fact is established? Then the Evidence Act will say that here the court will presume existence of certain affairs. So you have to have thorough knowledge with regard to the establishment of facts, presumption of facts. This is one side of the case. Second is you have also be extremely clear about the offenses which are alleged against that particular accused. You have also to be extremely aware about the factual requirements of that particular substantive offense. Number three, you must have also studied at your own level something of psychology, human psychology, with regard to its memories, with regard to exaggeration, with regard to observation. This is, you are supposed to have this prior knowledge. So when a witness comes in the court and you have to cross-examine him, I mean, it's not the question of whatever you want to ask him, you just ask him because it arises in your mind. What was the clothes he was wearing? What was it raining on day or snowing that day? Because these are just questions for the sake of questions. They are directionless. They are, unless in your mind you have thought of a defense that this witness was not the witness present at the time the offense was committed. So you are trying to judge his memory. You are trying to establish in the court that this witness is not speaking truth because he was not available, if that is your defense. So the cross examination must turn around the defense which you propose to take. You must have thought that in advance. What is it that I have to establish and prove? This is extremely important what I am saying. You must have thought what is the defense available to you. What has the accused told you? I have committed this offense or I have not committed this offense. You might seem to have committed this offense, but they may not have actually committed that offense. Just like in the films you see somebody holding a pistol and the person is dead. So everybody says he has killed him. It may not be true. Somebody else may have killed him. So therefore, cross-examination is more a matter of understanding, more a matter of knowing the direction of the questions you ask, more about psychology and about anticipated answers. About anticipated answers. I think I told you once. I can give you my personal experience. You have the time to hear. I know I was doing one this anti-corruption matter. It was a very watertight case. Investigating officer came as a witness, and I knew the answer. So I asked him the question. I told him that, is it true that the record in this case has been tampered? And I knew the answer. How will he say yes, it is tampered? He said, no, the record is not tampered. I said, it is possible it is not tampered only if you had retained the record with you all the time. He said, yes, I had retained the record all the time with me. I said, very good, and I stopped there. Sometimes it is important to know when to stop asking questions. When the hearing came, the judge told me I have to send these persons to jail. I said, you cannot send them. He said, why? I said, the sanctioning authority has not seen the record. He said, but in the order of sanction it is written he has seen the record. I said, read the statement of investigating officer. He says record was all the time with me. Then what has he seen it? That's a different way. That is how you skillfully handle a matter. So therefore, when in cross-examination, books will not help you. What will help is your own understanding of the prosecution case, your own understanding of the defense.
True, sir.
And directions of the questions. What is it that you want to establish? Yes.
Right, sir. So next question we'll take from Miss Ishrat Manzoor. Miss Ishrat, if you could please unmute yourself. So I think she is not available. Mohammed Asim, Mr. Mohammed Asim, if you could unmute yourself and ask the question, please. So yes, sir. I don't
Yes,
think.
Assalamualaikum. Actually,
Walaikum
it
assalam.
was controlled by the
Advocate Khurshid, sir.
No, Mr. Asim will ask a question and then Mr. Khurshid will give an option.
Yes, Mr. Asim, tell me.
Yes, sir. My first question is that an order has been set aside under recovery issue, summary issue, sir.
Okay.
I have been given the opportunity to present the written statement. My leave to defend has been allowed, but subject to the condition of deposition of rupees 2 lakh.
I think that is a requirement of law. The court can allow you to defend subject to conditions. That is in the CPC.
Yes, as such, I have gone through the CPC, but there is no such provision for imposition of condition or imposition of a cost.
No, it's not a cost. This is the condition of granting you the leave. But I think there is a court may grant you leave on such condition. If you read that provision, the book is not with me. You can read that provision. The power of the court to grant. If you are of the opinion, I will not contradict you. If you are of the opinion that the law does not empower the court to impose any condition, Then you question this order. It is as simple as that.
Okay, sir. I think we should leave this question there, sir.
Assalamualaikum, sir.
Walaikum assalam.
Mr. Khurshid, your question next.
Yes.
Assalamualaikum, sir.
Walaikum assalam.
Sir, at least I have not asked any opinion, legal opinion. Which everybody is
Okay.
asking.
Thank the Lord.
Sir, the golden principles of pleadings are generally that we have to plead the facts only,
Yes.
not the law. But sir, we are generally encountering these problems that lawyers plead the law and the evidence. Sir, but that is the prejudging the minds of the judges at times. Sir, how can we counter this problem? Either we have to this compromise with the golden principles which we have been taught in the academics, but in practical, we are seeing that so many lawyers are quoting the law, the judgments in the petitions. Sir, this is my simple question: that how we would counter these aspects, sir?
First of all, you cannot prevent the other lawyer from writing whatever he wishes to write. Now, second thing is you can always apply to the court for striking out the pleadings which are not relevant is number two. Number three is, which is easy for you, when he quotes a judgment and you find that the judgment is not relevant or distinguishable, you can always say that the reliance on this judgment is misconceived, the judgment is not, the judgment is distinguishable, or it does not lay down correct principle of law, or whatever you have to say. You can always say that. Do not go, listen to me one more thing, do not go by what others do. Go by your own confidence. You must be confident to deal with the case. When you are finding a written statement, go strictly by the law what the written statement should contain and what it should not contain. So, therefore, leave aside what the plaintiff has said, leave aside what other advocates do. But what you do is only about this part, that you do what CPC tells you to do. Because when the case will go till Supreme Court, this issue will come up, that what are the material facts, not the law. This will not go unnoticed. But at the trial courts level, it is all right. They do it. A lot of advocates do it, or they would like to make their petition quite bulky. They want to make their petition like that. That's a different issue. But in my opinion, you should stick to the requirements of the CPC and file your written statement accordingly. This is all I would tell you. Do not go what others do.
All right, sir. So, although we would have listened to you the whole night, and sir, just listening to you is such fun that we won't stop. But we understand that you also have your own time constraints, sir. And then our team, which is with you,
Yes, yes, only 9:45 for them. I'm looking at them.
Yes, yes, sir.
They must be getting tired.
We were in a mood, sir, to retain you even further. But I think we
No,
have
but it's a
to
pleasure talking to all of you because I love sharing my own thoughts, my experiences, and I want you also, not you alone, but all of the participants in this, that they must understand the legal practice requires lot of inputs at your personal level first. Those inputs are your knowledge, your understanding, which I earlier said, I won't repeat them. It requires lot of inputs at your level first. Then, of course, you follow it in the court of law. You understand what other advocates are doing, or what works, what does not work. That you will learn by and by. But you must improve yourself, and as I said, it is a work in progress all the time. You have to read, read, and read. Improve yourself all the time. Improve yourself all the time. That's all I have to say.
with this, sir. I believe that you have kindled or rekindled new fires and new works in progress for sure, sir.
Shallow. If I am of some
For
help,
future. And thanks
grateful.
a lot, sir.
Grateful
Now,
to the court cast. I
Yes.
found the name interesting. I'm grateful to court cast. Okay,
Thank you, sir.
for holding this. Thank you very much.
So,
Everybody,
sir,
thank you very much.
for
Allah
a formal
Hafiz.
vote of thanks, sir. Otherwise, Tausif won't leave me, sir. So kindly give him this opportunity for a formal vote of thanks. I would invite Mr. Tausif to give a vote of thanks.
Thank you so much, Mr. Fahad. You are a wonderful host as always, along with the team. So thank you so much, sir. Ladies and gentlemen, as we come to the conclusion of this enlightening lecture, I would like to take a moment to extend our deepest gratitude to our learned Senior Advocate Zaffar Shah, sir, for gracing us with his invaluable insights on the topic law in practice. Zaffar sir, your depth of knowledge and expertise in the field have not only educated us but also inspired a new generation of legal minds. You have illuminated complex subjects with clarity and provided practical advice that many of us will carry forward in our careers. I would also like to thank everyone in the audience for their active participation and thoughtful questions. It is your eagerness to learn that makes events like these successful and worthwhile. In closing, we are honored to have you, Mr. Zaffar sir, as our distinguished speaker. Your contributions to the field are immeasurable, and we are privileged to have had the opportunity to learn from your good self today. Thank you
Thank
and
you.
have a wonderful evening. And plus that, we are extremely sorry to the participants whose questions remain unanswered because we have to also see the paucity of time. Thank
But
you
then
so
we
much.
have to get sir again.
Inshallah, we will get
Our,
sir
you
again.
know, when you reach at my level, you will always have a competition with time, not with people, not with other advocates, but with time. 24 hours is a very short time for a busy advocate.
Thank you. Have a wonderful
All right.
evening.
All right. Allah Hafiz to all of you. Thanks very much. Thank you
Thank
very
you so
much.
much.
Great, sir. Thank you.
Thank you. Thank you.